Pues nada, comenzamos. Yo no sé si se escucha, si no, si está conectado, vale. Pues muy buenos días. Bienvenidos a la Universidad Pontificia Comillas.
Welcome to Comillas Pontifical University. My name is Federico Montalvo, and I'm the Vice Chancellor of International Institutional Relations and Secretary General of the University. I've been asked to participate in these days to give the opening speech. It is a pleasure. There are different reasons why. First of all, seeing Cedric again after all these years, it's great. He's been in United Nations and all over the world, so it's very good to see him again and going back to this kind of new normality, although we're still living in this special situation. And then there's Professor Isabel Lázaro. Everything related to children touches me, and it also concerns me. Because I was also researching everything related to rights of children, and it's a topic that particularly interests me. I've been studying this for 23 years, and all these topics related also to children's health, that has been a hot topic. It's very interesting again, and as I say, I've been concerned by this, so that's why I spend time researching this topic. I think it's very important to talk about child justice. We are living difficult times, and once this session is over, I've been asked to speak about Ukraine. We are in favor of Ukraine and would like to have a minute of silence for peace and for Ukraine. It's a very difficult topic to talk about, and we're talking about barbaric events. It has to stop. We can't have discussions, we can't talk, we need to stop this. So that's why once this session is over, we will have 1 minute of silence, and then we will go on with the day. Speaking of justice, in this awful time, is extremely difficult. We have just come out of a pandemic, or actually we're still on it. But hopefully we are getting to the end of this if a new variant doesn't come up. But as I was saying, after this situation now, we have a more difficult hazard. And it's a desperate situation. Traumatic experience, most of the time, make people understand what life is about, what hope is about. And it seems that some have not learned after this pandemic. Those of us who study law, constitutional law, we are very touched by this, and we are kind of hopeless after what we are seeing. Having said this, I know it was a bit pessimistic, but it's difficult to be optimistic after a mortal pandemic and after a war. And there's just one person to blame, and the community that goes with it, and I'm speaking about the President of Russia. So after having said this, I'm going to leave the floor to different speakers. The first person that's going to speak today, he's the responsible of the program Access to Justice of Terre des Hommes. He will speak now in French. So if you want to hear the Spanish interpreting, you can do that by changing the channel. You have the floor.
Merci beaucoup. Monsieur le vice-recteur, monsieur le directeur de l'enfance de la communauté de Madrid, mesdames, messieurs, chers collègues, chers amis, je commencerai ces quelques phrases par faire des références récentes à quelques discussions que j'ai pu avoir avec certains et certaines d'entre vous hier dans la journée. Alors, j'ai échangé justement avec une éminente professeure de votre institution hier qui me disait que, notamment en Espagne, mais je pense que nous pouvons élargir le constat à bien d'autres pays. Donc, vous me disiez, Isabella, que beaucoup des mineurs en conflit avec la loi émanent tout simplement de nos propres systèmes de protection. Je discutais également avec une autre collègue hier, Alexandra Martins, qui travaille pour l'Agence des Nations Unies contre la drogue et le crime. Et nous discutions, il y a aujourd'hui, au niveau des taux de détention, globalement, nous considérons que 70% des détenus sont en détention préventive ou en détention provisoire. Et nous avons procédé à quelques études dans certains pays. Et en étudiant les chefs d'inculpation, nous nous rendons compte que plus de 60% de cette population qui est en détention préventive serait éligible à des mesures de déjudiciarisation. Cela nous dit que globalement, 50% environ des détenus dans le monde n'ont rien à faire en prison. Un troisième exemple, et nous en parlerons aussi cet après-midi lorsque nous évoquerons la justice communautaire notamment, ou la justice informelle, il est considéré aujourd'hui que plus de 80% des décisions de justice dans le monde et dans les pays en développement essentiellement sont rendues au niveau communautaire, au niveau coutumier, au niveau traditionnel ou au niveau informel. Alors, qu'est-ce que ces trois exemples finalement nous disent ? Ces trois exemples nous disent, et en tout cas j'en ai la conviction, qu'il faut aujourd'hui, en matière de rendu de la justice, notamment pour les enfants et pour les jeunes, qu'il faut envisager tout simplement de nouvelles voies, des nouvelles voies probablement plus innovantes en termes de réponse. Il faut davantage nous concentrer sur les pratiques. Le constat que nous faisons globalement, et dans le domaine de la coopération internationale, c'est qu'on a cette fâcheuse tendance à nous concentrer parfois sur des grandes idées, sur des éléments de culture, sur des éléments conceptuels. Et en tout cas, nous pouvons constater dans la plupart des pays, notamment dans lesquels nous travaillons, au niveau de la Fondation Terre des Hommes, mais aussi, j'en suis sûr, au niveau de UNODC, nous constatons que la question des pratiques reste, en termes de réflexion, largement sous-exploitée et sous-pensée finalement. Le droit n'est pas une matière figée, loin de là. Les institutions le sont peut-être un petit peu plus, mais nous sommes convaincus qu'avec une meilleure collaboration ou une collaboration plus soutenue entre le monde universitaire, entre le monde de la société civile et entre les institutions judiciaires au sens large du terme, nous sommes convaincus qu'une meilleure collaboration dans beaucoup de pays permettrait de renforcer l'accès à la justice pour les enfants et pour les jeunes. Alors, la dynamique, nous sommes ici aussi aujourd'hui dans le cadre de la suite du Congrès mondial pour la justice avec les enfants qui a été organisé en novembre 2021. Ce congrès et la déclaration qui en a émané et qui a été traduite en 40 langues nous dit effectivement qu'une meilleure analyse des enjeux globaux et qu'une meilleure mise en pratique des recherches et des éléments que nous avons pu étudier serait vraiment un avantage considérable. Je crois qu'il y a aussi aujourd'hui deux enjeux très très importants et d'actualité, et nous en parlerons dans la journée. Il y a deux enjeux d'actualité, c'est la question de l'environnement et des droits de l'enfant, qui nous amène tout simplement au droit à la vie. Si nous regardons la Convention des droits de l'enfant, il ne faut pas forcément chercher plus loin. La question de l'environnement Et les problèmes environnementaux, les changements climatiques nous ramènent directement à un des articles de la Convention qui fait référence tout simplement au droit à la vie. Alors ce n'est peut-être pas si simple, mais c'est certainement le point de départ. Nous devons également considérer l'évolution de la digitalisation, le monde digital, et le mettre en perspective avec les droits de l'enfant. Il y a d'excellentes pratiques, il y a d'excellentes innovations, mais il y a aussi des dérives. Nous en parlions récemment avec mon collègue Cédric. Dans certains pays, pour ne pas les nommer, nous constatons aujourd'hui que la e-justice, ou les cours à distance, les tribunaux à distance, ont engendré, alors ça apporte des solutions, certainement, ça apporte une solution immédiate, notamment en situation de crise sanitaire, mais d'un autre côté, nous avons constaté aussi que dans certains pays, où il a été constaté dans certains pays, que finalement les taux de détention ont aussi augmenté depuis que nous travaillons sur des questions de tribunaux à distance ou de tribunaux digitaux. Je n'irai pas plus loin, je remercierai chaleureusement l'Université Comillas qui nous accueille et qui nous fait l'honneur de nous accueillir dans ces locaux. Merci beaucoup. Particulièrement aux professeurs Isabella Lazzaro et Myriam Cabrera, qui ont été en quelque sorte les chevilles ouvrières avec nous de l'organisation de cet événement. Donc merci beaucoup. Et je remercierai aussi mon collègue Jesus et particulièrement la fondation, je vais essayer de le dire en espagnol sans trop écorcher votre belle langue, la fondation Tierra de Hombres. Donc merci beaucoup pour l'organisation, Jesus, et pour votre accueil. Merci.
Muchísimas gracias.
Thank you very much, Jan. Now I would leave the floor to Alberto San Juan. He's Director General of Family, Children and Natality of the Community of Madrid. Thank you, Alberto. We are living difficult times, as we've already said, but for me it is a honor to be here today. Thank you for coming to this event, to this day about justice and child justice. We do have many experts. Maria Antonia, she's a friend of mine. She called me, giving me the opportunity to be here today, and I didn't have to think it twice. I immediately accepted. As I was saying, for me it is a honor, but it is also a duty. I support all initiatives related to child justice. All children should be protected, legally protected by institutions. And that is why it is very important to have entities such as Tierra de Hombres or Terre des Hommes. We support these type of initiatives. I would also like to welcome and congratulate Tierra de Hombres from Spain. Thank you for organizing this event. They have been working for 30 years in Spain with the aim of improving the life conditions of the most vulnerable populations. They have been working on children's rights, and they're looking for a world where children can live with dignity. And these children need to grow up in an environment that protects them. I would also like to thank the university. Thank you, Federico. And I think it's very important that university participates in these types of events about children and justice. I would also like to thank the Infancy Platform for participating. And finally, also, I would like to thank the Spanish Agency of International Cooperation, because without them, these would not have been possible. We're not talking about social classes. Child maltreatment is everywhere. And it is especially hard for those who are not protected. So that is why it is very important that children, minors, are defended. These children often they feel guilty because the system does not put trust in them. At the end of the day, adults end up also being they also end accomplishing these aspects. We hope that these meetings will be useful for the Congress that will be held in 2024. Hopefully this Congress will be celebrated as well in Madrid. These international dialogue days have a goal to speak about children, about adolescents that are in contact and in conflict with the law. We will speak about the conclusions coming from the Congress held in 2021. We will also speak about three main pillars that were discussed: climate justice, digital justice, and child justice. The idea is to create a space where we can discuss and reflect, speak with experts and authorities to advance in this problem. Speaking on behalf of the Family, Children and Natality Directorate General of Madrid, we have different objectives. We want to protect natality, we want to protect children, but we also want to promote this natality. I will briefly speak about how important it is for us, this topic. It is one of our main axes. When we speak about promotion of natality, we're not speaking about policies that try to improve this natality. We don't want families having as many children as possible, but rather to enable these families to have as many children as they want. In 2021, we carried out a survey and we asked families if they had all the children they want. And women, and today is a special day to speak about women. As I was saying, these women, they said that they didn't have all the children they wanted. For us, for the community of Madrid, this was a challenge. We want families to have all the children they want. That is why we adopted a strategy to improve natality. We have 80 measures. And we have a budget of more than 400 million euros. We want Madrid to become a region to support families, a region open to life. And we want families to have as many children as they wish. This is one of the most important strategies ever carried out. And not just in Madrid, but I would say in the whole territory of Spain, and I would dare to say also Europe. That is our commitment, to support families, to enable them to have as many children as they want. It is not easy, that's for sure. But as I said, it is our goal to become a friendly region. We also have an aid of 500 euros, and we will give this aid to all women under 30 years, starting from the 5th month of pregnancy. All these women will receive direct aid of 500 euros until the children becomes 5 months old. 2 years old. It is very sad to see a family that wants to have children but that can't have them. Politicians need to solve problems of citizens, especially in these times. So from the Directorate General, that is our goal, to support families. We are very proud of this, and we are hopeful to help all the families that we can. And without further ado, I would like to welcome you again. I hope it would be a fruitful conference. And I hope that we can speak about children and adolescents, which is our main topic today. Thank you very much. I don't know if I need to leave the floor to someone else. Well, thank you very much. Don't worry, you could have the floor a little bit more. Now I'll give the floor to María Antonia Jiménez, who is the president of Tierra de Hombres, Spain, and she will connect online. María Antonia, you have the floor.
Buenos días.
Thank you very much. Good morning. Well, first of all, I would like to hug virtually all my colleagues. I wish I could be with you today. I would also like to welcome all of those who are connected with us, not just online, but also physically. And it is a pleasure to hold these events in the university, so thank you, Federico, as well. Thank you, Mr. Montalvo, for giving us your home, opening us your doors. So we had students from Comillas University coming to Tierra de Hombres to do their internship, and it was always a pleasure to welcome them. I would also like to thank our Director General of Family, Children and Natality of the Community of Madrid. I think it's wonderful, the policy that they are implementing. The Community of Madrid has been helping Tierra de Hombres for years. They have supported all our programs, especially one called A Journey Through Life. We are honored to open this wonderful event, and we are very lucky to have this institutional backup. Soon we will also hold an international congress in Madrid, and it is wonderful. Children deserve justice, and Madrid will participate in this. Jean Collieu, thank you very much as well. He's the responsible of the program Access to Justice of Terre des Hommes, and he's my colleague. We've been working for years. He especially has been putting all his efforts to ensure that children can have dignity in their lives. Tierra de Hombres Spain has been working together with Lausanne for years. I would also like to thank all the team that has been working from Spain. Jesus Perez Campo, thank you very much. And thank you to all the team that has come from Lausanne to carry out these days. We are living a post-pandemic era, and we are suffering strong impacts coming with climate, economic, social crisis. We will experience family conflicts, unfortunately. And we are living in very difficult times with almost 2 million refugees coming from the war. All of those who are responsible for children and those in charge of judicial systems, we need to work together in order to make sure that we can progress. We need to ensure societies with strong protection systems, because we will experience suffering. Children will experience suffering. I would also like to thank all the national, international experts. Thank you for accepting the invitation, and thank you for coming to this event. Tierra de Hombres is already envisaging what will happen, and it envisages all the, unfortunately, humanitarian crises that will happen. With Jean-Claude, we already worked on implementing action in Mauritania to guarantee access to justice for children. Within this convention between Lausanne and Spain, I would also like to thank especially one person. We will draw very important conclusions, and that is thanks to the Spanish Cooperation Agency. Children are one of the most vulnerable groups. They are vulnerable to abuse, to migration. Those migrations that can be forced or voluntary, it doesn't matter. But there are many children in conflict with law, and they are not backed by law. And it is a right that appears in the Convention of Children of the United Nations. Children have rights to food, but they also have rights to justice. Recently, a report was published in 2019, and Tierra de Hombres participated in this report. And we were astonished by seeing that 1.5 million of children were deprived from liberty. Thank you so much to all of you who have made this event possible. I would like to speak about the global initiative of children and justice. This is a very important work that has been carried out because very important conclusions were drawn from this. And I hope that in the next Congress that will be held in Madrid, we can tackle these problems. And we will count on the support of Community of Madrid. Thank you to Plataforma de la Infancia, Infancy Platform. Thank you, because they have been working with us and together also with the Spanish Cooperation Agency. Thank you. Thanks to your support, we have drawn important conclusions that serves as guidelines. And this is extremely important. Finally, there are many children and adolescents that they carry out an offense, they commit an offense, but because they have no choice, and they end up being incarcerated. And it's a trauma for them, not just physically, but also psychologically. And we have asked governments and institutions to solve this problem, because we cannot allow this. The traffic of children, for instance, among other problems. That's what we call out for new systems. The judicial system has the obligation, the duty to follow these children, to help them, to protect them. Let's not forget that children should not be in jail. All children around the globe have the right to fair justice. Again, I would just like to thank all my colleagues, all the speakers here today. I would love to be here with you physically, but finally, I will just say something. Sometimes we need to be hurt and we need to be pinched to understand that what we are living, it is a reality. It is not a dream. We're seeing horrible images of families that are fleeing their countries. So I would just like to mention the Ukraine crisis because I think it's something that we need to tackle here today. Thank you.
Para nosotros no es que sea un placer acoger estas jornadas, es que es algo más.
Thank you so much. I have to say that for now it's not only a pleasure for us, it's our duty. We have to host this international journey. We are a very important institution and we rely on humanity and justice. And those values are extremely important and they prove that we should treat children as they deserve. But not only this, not only treating kids that go well, but also the kids that are struggling, children that commit some offenses. Those are the ones we have to support. Several experts have told this before, over and over again. This pandemic left some barbaric actions, and it will continue. What are the impacts of losing taste or losing the ability to smell? But then what are other long-term impacts? Some experts have also said already that we will have consequences on mental health and mental health on children. Of course, many times these mental health issues are also related to children and justice. It is our duty. I insist. We have to comply with our paradigm and our values. So I appreciate so much that you organize this International Day. So I'm very happy to say that these are officially open now. And I would like to ask all of us to please take part in 1 minute of silence. I have to say that my mom is 50% Finnish. My family doesn't live far from the border with Russia. So you can only imagine how worried I am as well for this situation, not only because of my family, but because I'm a human being. I insist, please let us celebrate 1 minute of silence for the Ukrainian people and the Ukrainian children. Everyone who is struggling with this terrible war. Thank you.
Muchísimas gracias, que disfruten las...
Bueno, pues voy a quitar la máscara.
I'll take off my mask while I'm talking. Thank you very much, everyone, for being here, in person and online, of course. Given our actual world, we are very forced into being creative and coming up with events that can be fruitful for everyone, or for most of us. And we now have to go for hybrid events. I would like to welcome everyone, people in here, people remotely. And for me, it's a big honor. It's a very, very big personal honor to come back to Comillas University. I'd rather not say how many years ago. I don't even want to think about how many years. But I was working here many years ago with Isabel. We worked on the law 5-2000, which is the law for criminal law for children in Spain. And I can still remember the meetings and the conferences that we had with colleagues from Comillas. They were all very fruitful, enriching, and very interesting. So I'm very happy to be back in this wonderful place. Today we are hosting this first preparatory meeting on justice with children. Along with my colleague Mariana here, I will be talking about our activities and our objectives for this International Day. This global initiative is a movement organized collectively among different organizations. Terre des Hommes Lausanne organizes it with Penal Reform International, with RP as well, and also with the Institute of the Rights of Children. These organizations, along with other NGOs, have agreed to cooperate together to face the challenges and the current issues that we have regarding justice and children. This global initiative began in 2019. We celebrated the 30th anniversary of the Commission for the Rights of Children. And the idea for this was to initiate a movement that would last for years, that would involve people, that would increase the network, the international network of justice with children. We mostly have two courses of action. The first one is the Global Congress on Justice with Children, the last event being in 2021. Officially in Mexico, in fact online, as you can imagine. What we talked about then were the most important challenges that we have currently. You may see the global congresses that we've had. First one in Lima in 2019. We focused on restorative justice. It was in fact one of the first events that we celebrated. And it was especially one that we focused on how to apply restorative justice to children. From then on, many international mechanisms were developed. Then in 2015, the Congress took place in Geneva. It was a place for discussion and observing on the Committee on the Rights of Children how to revisit juvenile justice. Then in 2018, from a very different world, we focused a lot more on how the radical movements were emerging. We talked back then about extremism and violence, and we thought about how the academic world could respond to these important issues. And this was the first event organized by the same organizations taking part in this today. We hosted around 14 preparatory meetings for the Global Congress in 2021, back in November. We discussed discrimination. The Mariana will comment a bit more on. And then we'll also comment on how to organize the 2024 Congress. Thank you very much. It's a real honor for me to be here today. I'm thrilled to be here and taking part in this organization with Cedric and our other colleagues. Last year, for the 2021 edition, I took part in as well. We talked about different issues that children have to face. And the good thing is we came up with possible challenges emerging post-pandemic, environmental issues, and this is what we talked about. So as we said, the Global Congress last year was held between the 15th and 20th of November 2021. We simply wanted to ensure that we would give justice to children and that we looked for justice systems that were non-discriminatory and inclusive. The Supreme Court of Justice of Mexico was the host of the event. And as you all know, sadly, we had to hold it online because of the pandemic. But it was good because we did have so many participants around the globe. We held 92 workshops, 72 regional and 18 international. In North America, we had regional workshops, as well as in any other country and continents. In the Caribbean for the first time as well, I should say. In Africa, Europe, Asia, in the Middle East and Northern Africa. In these workshops, many people gathered. Around 4,800 participants took part in these workshops from different generations. And this is very significant. The most important thing from 2018 to 2021 was the increase in child participation in this Congress. Back then, we talked about justice for children, but then since 2021, we're talking about justice with children, which is very important. We also listen to children and their experiences in the justice system. As you can see in the image shown in the screen, one creative artist designer created this for the Congress. And what was shown were the challenges children face. And the idea was not to do it for them, but with them. So you can see we did have many child-friendly initiatives. But then what were the topics for this Congress? Well, obviously discrimination was one of them. Then racial discrimination, gender discrimination, sexual discrimination as well. We also talked about children affected by immigration. And then children, unaccompanied minors as well, were discussed. It was important to know about them, the stories of parents. We also talked about health issues and, offenses related to their age. Additionally, we made sure that the voices of said children were heard. For the advisory group of youth and children. So what happened was that we wrote this global declaration on justice with children. This consortium of the Global Congress was in charge of drafting this declaration. And said children that suffered several issues related to justice were also involved in this. So it was very important to have everyone involved, also the scientific committee and the experts and all stakeholders and participants of the Global Congress. They are part of the academic world and civil society. The good thing is, this was realizing that justice is with children, both now and in the future. We also addressed some issues on climate change, mental health, and of course, community justice. Of course, we cannot forget the equal access to justice and also a justice adapted for children, especially for children in contact with the law. It was very important how children participated. It was one of the pillars of this declaration. Why? Well, because it was the first time children were actually saying something about their justice issues. And who signed this? Justice with Children, Tardezan Penal Reform, the Association of Judges and Magistrates for Family, the Institute of International Rights for Children. And of course, these signatories are also also include institutions from the UN, as UNICEF, you can see. Of course, we also had the representative for the rights of children, the United Nations International Office on Drugs and Crime, Pathfinders, Baker McKenzie. Pathfinders actually advocate for the Article 16 to protect children as well. Thank you very much, Mariana, for this. As you were saying, I'd like to stress that there's a very important point in this declaration. And the fact is that it's not just only a declaration signed about justice with children, but it's a declaration that's signed by organizations belonging to many different sectors. And for us, particularly, this was already a challenge to get that many people to sign and cooperate for this. Today we have a long day of work ahead. We'd like this meeting to be quite dynamic, and we'd like to talk about quite different topics. The main objective of this International Day is to discuss 3 pillars. These 3 pillars were extracted from this past conference that we discussed, the Global Congress. I will comment a bit further on this, but for now we will be talking about climate justice, digital justice, and the empowerment of the community. As Federico discussed before, and he commented on this, based on the actual recent events, on the conclusion of this conference, we will comment on children being involved in an armed conflict situation. I'd like everyone to think and discuss about this. In this hybrid event, we have multiple opportunities. We can have people from many different countries being involved in these discussions. As you can see, well, you will see now that our colleague Angela will be talking from Miami. She'll be in a rush, though, because it's 3 a.m. there and she will probably want to get back into bed. But the idea is to think about this together and think of how we can cooperate together. I'll comment on these objectives briefly and then we can move on. Of course, we need to discuss together. I already said it. But there's more. We have political guidelines and roadmaps that we have to follow. Digital justice will be the first topic we will be discussing. As you know, the digital transformation has accelerated in the world. in 2020, we stopped for 6 months. Nothing worked. The justice stopped. But then we had to be very resilient. We had to come up with solutions. What did we do then? In around 20 countries, we carried out some research. This research was based on surveys with judges, magistrates. And we were very interested in knowing how they had adapted to this situation. Responses were very interesting. And of course, there was a very big chaos of good intentions and good initiatives. Good initiatives on how to improve justice, how to make it closer to citizens, and especially to children. How can we use new technologies for this? This is undoubtedly the future. We can clearly see it's moving already. Although we should never forget that we can never forget the rights of children in all of this evolution. What are the guarantees for children in justice systems? So this is something that we will be discussing. We're very concerned about what are these procedural guarantees for children regarding digital justice, of course. We will then move on to climate justice. As you can imagine, it's a very important topic. This is a bifold topic, really. On the one hand, we can talk about the access to justice of children who would like to express their concerns on climate change, of course. What are the causes for climate change? Of course, we all know the movement Friday for the Future by Greta Thunberg, of course. What are the risks children will be facing? And of course, it's important that we listen to them. Then, as I said, on the other hand, climate justice also relates to the fact of how climate change is actually pressuring justice systems. There are multiple reasons for this. The demographic pressure, the change of immigration flows, all of that involves climate justice as well. So again, we will discuss together this particular issue and hopefully try to come up with a statement and analyze the approach of the Committee for the Rights of Children, who is currently drafting their general comments. Finally, the third pillar we will be discussing is the empowerment of community and restorative justice. This is very important for Child Islam. We want to participate actively with several actors from the justice systems. We're talking about indigenous justice, about local religious justice. And these are justices that we are not used to discussing, but that it's very important to do so. Our colleague Jan will comment more on this afternoon. It's very important. Most countries actually represent this plural justice within themselves. One of the examples that we want to particularly comment on is the difficulty in implementing the restorative justice. This preparatory meeting is an opportunity. It's an opportunity for us to present the work we have done in Mauritania. And I will leave the word to my colleague Jesus to comment on this. Thanks very much to both of you. I'll be very brief. Our colleagues are waiting for us. I would like to thank everyone for coming, of course. We have already heard some participants, as you know, the president of Child Islam Well, the participation would not have been possible if ICID had not been involved in this. This event can be found within the framework of international cooperation. It's very important to ensure the access to justice for children. And in this case, we're talking about Mauritania. This project began in April 2019. We're almost finishing, actually, because it was meant to last for 4 years. These international days of discussion are also part of the project, because the objective is to raise awareness on the importance of justice. Of course, not only in Mauritania. The agreement that we came up with was designed in 3 pillars, and it had 3 main objectives. Number 1, ensuring access to justice, teaching and forming the population in Mauritania. We had to form people and teach people on the rights of children and access to justice, both national and international individuals. The second objective was to reinforce the application of constitutional justice. That means the application of justice within the country. What we did was work with local institutions and organisms to work with children, support them socially. We would normally look for alternatives for children. Alternatives to ensure that punishments were less harsh. Now, in this regard, everything is, of course, applied in the legal system of Mauritania, of course. And we have a very special role in this. The third mission that we had, or the third objective, was basically preventing violence, especially gender violence, a violence that would affect little girls and women, females that are invisible in this society. And this is a very big issue, an issue that sometimes goes unseen because it is not commented on. And our role was basically to focus our support in this. We'll discuss this forward in this restorative justice section. The good thing is, in this project, we are not only focusing on traditional justice, we're talking about constitutional justice as well. We'll go deep into the meaning of these terms further on. We have drafted a study. We'll show you a sneak peek later, but we are trying to get this published as well. We would like to focus on a justice system that is actually living along the customary system that they have in Mauritania. And maybe in Spain we see this as, far-fetched, but it is possible. So we will now move on to digital justice and the challenges that these poses to justice. Thank you.
Bueno, muy buenos días a todos y a todas.
Good morning. My name is Carles López, and I'm a president of the Platform for Infancy. It's the network that coordinates 75 entities about infancy at the state level. It is a pleasure to be here, and thank you very much for organizing this event and for inviting me to moderate this roundtable. I think it is always good news to have experts from different areas in the same roundtable, from academia, from institutions. It is good to have this sort of participants to speak about the rights of children. Also, today we're speaking about a very interesting topic. We are in a changing society, and rights of children are threatened, constantly threatened. We are seeing it, how all around the world the rights of children are being threatened. First of all, we had the pandemic. The rights of children were affected because schools were closed down, but there were also restrictions to leisure. There is another topic framed in this area, which is the access to justice. Access to justice, this is what we're going to talk about today. The idea is to make this roundtable very dynamic, to have an open discussion. International experts will participate and give us their vision, but we also have national experts and audience, both physical and online. And the idea is to, as I say, hold a debate around this topic. The pandemic has restricted access to justice for children. Why? Because we had to do this online, and this led to new issues that need to be debated, discussed. Some are related to the Convention of the Rights of Children, the CRC, right to privacy, among others. But other issues, such as whether a fair legislative proceeding can be secured for these children, and also other topics related to digital justice. So I'm going to give the floor to Alexandra Martins. She's the director of the global program of the UNODC for children, to end violence against children. She has been working in protection of the rights of children. She has also worked on policies and the creation of laws in different countries around the globe. And she has been working for 25 years in the criminal area, in the protection of children. She's been working on different NGOs globally, and she is now strong responsibility. So she is going to speak now. Thank you very much for being here with us today. You have the floor.
Muchas gracias.
Thank you. Good morning. It is a pleasure for me to be here today. I would like to thank the organizers of these events, and thank you to my friends of Comillas Pontifical University. It is truly a honor. I would also like to thank my friends of Terre des Hommes, Jean, Cédric, Mariana Calorina. Thank you for making us participate. If you allow me, I'll speak in English.
So, ladies and gentlemen, I would like to greet my colleagues who are joining online. In particular, Angela, it's a pity you are not here today with us, and everybody who's attending this event online and here. On behalf of the United Nations Office on Drugs and Crime, as I mentioned before, I'm delighted to be part of this meeting, and in particular this important discussion on children in the digital world. First of all, before talking about the challenges posed by new technologies in this area, I would like to start by defining the scope for our discussion today, or proposing the definition of the scope. What are we talking about when we refer to children in the digital world in the justice context? So I think it's important, first of all, to differentiate and adapt our discourse according to the nature of the legal proceedings that we are talking about. So we know, for example, that issues faced by children in relation to technology may not be the same for civil, criminal, administrative, or immigration proceedings. As we know, the laws, standards, norms, as well as the stakeholders will vary. So I think that the first question that I put myself was why juvenile justice is different, and in this sense we go back to the origins of what we are talking about. Why there is a specialized justice system for children, what is its role, and what are the key principles. And I find it interesting that we always need to go back to the origins and to talk about this, to contextualize what we are talking about, what are the challenges, what are the opportunities that we have ahead. So let me also mention that for the past years, my colleagues and I, in the Global Program to End Violence Against Children, we have been working with member states to assist them in their efforts to prevent and respond to violence against children in the field of crime prevention and criminal justice. And when we receive requests for technical assistance, we still observe that many countries have the impression that they need to choose between two objectives, either preserving public safety or protecting, promoting, fulfilling child rights. Still, there is a tendency to think that these two objectives are contradictory. There is a tendency everywhere to think that there is a dichotomy between these two objectives of preserving public safety and protecting child rights. So in our view, it is our duty to make sure that these two interests are understood as being complementary and that we address efforts towards achieving these objectives in a concomitant manner. But in order to do that, I think it's a requirement, it's to start thinking outside the box and to move away from these purely punitive justice approaches that we see everywhere in the world, recognizing the importance of justice to be indeed conducive for a child to assume a constructive role in society. Child justice systems, as envisioned by international law, are meant to be highly specialized and multidisciplinary systems where the pursuit of public safety and the fulfillment of child rights go indeed hand in hand. And that makes them the most appropriate forum for dealing with any case involving child alleged offenders. So as such, child justice systems are bound to respect certain key principles that are set forth by international law. And we can mention the principle of non-discrimination, the right to life, development, dignity, the best interests of the child, the right to participation, proportionality, the primacy of alternative measures to judicial proceedings, proceedings without delay, presumption of innocence, detention as a measure of last resort. So we know I'm not going to mention our principles or to talk about it because this is not the right moment to talk, but I would like just to mention that these principles have to be respected in all circumstances and may not be subject to any exception or derogation, including during times of crisis or change in which we are living right now, as well as when adopting new modalities or using new technologies. So basically, I would like to start by saying that it's important, in my opinion, to go back to the roots, to talk about the dual role of the juvenile justice system, to talk about its key principles, before we put the questions about e-justice and the use of technology, audio-visual links. So while we have to recognize, and my colleague Cedric mentioned this before, that using technology is easy and there are many advantages, there are other questions we need to ask ourselves with regard to the use of technology, and that these questions are certainly more difficult to answer. So first of all, we need to understand whether replacing certain in-person proceedings with video conferencing has or will have an impact on the substantive outcomes in child justice proceedings. I think this is the first question. But we also need to ask ourselves questions to evaluate the impact of the use of technology on the factors that will affect the outcomes of child justice proceedings. So these are two ways of looking at the same thing. And I think it's important to differentiate between question 1 and question 2. And indeed, to better understand the challenges and the impact of technology on child justice systems, we need also to look how it affects the performance of the child justice system, how it affects the actors, the key actors that are involved in this process, judges, prosecutors, witnesses, jurors, and of course children. So it is crucial that we continue our research and discussions to answer these questions, because the truth is, whether we like it or not, the use of video conferencing, the use of technology has become part of justice systems, and even if the pandemic ends, these changes might stay. So change requires us to adapt. We see a tendency of resistance in relation to the use of technology, but this is, in our opinion, an opportunity that we have to look ahead, and an opportunity we have to perhaps rethink child justice and to create the conditions for protecting and ensuring the rights of children during the use of new technology. So today we know, talking about the advantages, we know that there are indeed some advantages of using, for example, video conferencing in proceedings involving children, including the obvious reasons Ian mentioned during his opening remarks related to health concerns during the pandemic, some of which have been already highlighted and evaluated through research. Video proceedings have shown to enable legal aid organizations to serve previously underserved geographical areas, and have also opened up greater opportunities for pro bono representation. In certain cases, we know that children may find that online proceeding will be able to reduce anxiety normally associated with attending court in person, and there may be positive effects of the use of video links associated also with reducing the risks of re-victimization by avoiding direct contact with the offender for child victims and witnesses, for example. But now talking about the disadvantages, while we know that these positive elements are certainly encouraging, and they are related also with the performance and efficiency of justice as a service, the concerns and risks of using technology are, in my opinion, to be taken very, very seriously. So we know that research suggests that video proceedings have exacerbated issues related to children's effective participation in the justice process. It can make, for example, lawyer-client relations more difficult, undermining communication and the relationship of trust between the lawyer and the child, as well as the lawyer's capacity to provide adequate support and assistance to the defendant. In addition, there are concerns about its impact on children's ability to understand legal processes, as well as the seriousness of the proceedings. I think it's very important also to mention the digital divide, causing inequality in access to services and rights during the use of video conferencing, which has also been highlighted as a challenge, further disadvantaging underserved communities and children. And finally, children themselves have expressed, there are a number of research that consulted children, have expressed their frustrations and anxiety in relation to a lack of understanding, privacy, access to lawyers, and support persons associated with video proceedings. So in conclusion, the question I ask myself is, how does all of this affect juvenile justice principles and how we thought juvenile justice or child justice should be? These concrete challenges have a greater impact on efforts of child justice systems to respect the key principles set forth by international law. The right to non-discrimination may suffer when children from marginalized communities cannot access video proceedings due to unequal access to technology and lack of knowledge on how to use it. The right to participation may be in danger when children are not informed and assisted in a child-sensitive manner, as they are struggling to understand video proceedings and to express their views in an unknown and stressful environment. Proportionality may be at stake when judges, prosecutors, and jurors cannot look children in the eyes, read their body language, and better assess the human impact a sentence may have on a child. What should therefore be our conclusion? So based on these elements of decision that we have available today, I believe we are in the middle of an ongoing pandemic and ongoing results, both of which persist and will change the way we approach and define child justice in the future. So we need to pause. I think this is really an opportunity for us to pause and reflect on what we know and what we need to know to assist countries in ensuring that child justice systems better serve and protect children during these proceedings. Certainly more research is needed. I think that more and more we need to use the advantages, the knowledges, and the skills that we have in the academia. We need to understand how video conferencing, for example, and other technology have affected the outcome of justice proceedings and what is their impact on child development and on how children perceive and understand justice. I see a tendency of focusing the research on the effectiveness and performance of the justice system. I think there is a need to focus research on how children perceive and their relationship with the justice system. We are restoring, we are promoting reconciliation between the involvement of children with the child justice system. And I think there should be a focus of research on this as well. Our future decisions should be based on the performance and outcomes of our current justice systems. We need to learn from our mistakes and make our justice systems more child-sensitive. We need research on how this technology will undermine the implementation of child justice principles to see whether and how they are compatible with the use of technology. And in the meantime, we need to look at the facts. With this, I conclude. I apologize for speaking too long. Courts all over the world are already using this technology. And as I mentioned before, we may not be able to go back. This is why we should advocate that courts, while developing policies for remote proceedings, consult with a broad range of stakeholders and apply a multidisciplinary approach adapted to child justice. So legislation should ensure that child justice is applied in line with international law, as set forth in the Convention on the Rights of the Child in the first place. Relationships between justice professionals, lawyers, judges, prosecutors, and children may also be bound to change. So we need codes of conduct, for example, to be adapted to this new digital environment. We need mitigation measures to be put in place when we are moving forward with video conferencing involving the private sector, communities, civil society organizations, and children to change and innovate the way child justice proceedings are carried out. This is definitely an opportunity for the international community, for the academia, for governments, for communities to step in. And let us work together, hopefully. I think this is the beginning of a long process to discuss and advance responses and solutions that are adapted to the new digital environment and protecting child rights. Thank you very much. Gracias.
Muchas gracias.
Thank you very much, Alexandra. Don't worry if you took a bit longer, because your participation was extremely important and it was a very good introduction to the topic that we're going to talk about today. So I think it gave us food for thought.
Damos por tanto ahora la palabra, que ya la veo por aquí en pantalla, Angela Vigil,
now
que es
I will give the floor to Angela Vigil. She's the Executive Director of Pro Bono Practice by Baker McKenzie, and she has been working for years in terms of rights of children. She has worked in public law, and she currently works representing children in all courts. She has also been awarded for her work in terms of human rights and defense for the rights of the children. And also it's important to mention that she led a project in the White House about children and technology. So that's why I think it's very important to listen to her today. I think she will give us a very interesting approach and vision of how children's rights are tackled in the digital environment. Angela, thank you very much.
Thank you so much, and I hope you can hear me. Although I'm viewing the room from the online version, and it appears I'm huge on the screen, so I know you can see me. Can I just get a sound check that you can hear me?
Yes.
Thank you. Hello, everyone, and I am so sorry not to be there in person today. It is my pleasure to be speaking alongside Alejandra, and I'm very interested in the perspectives of the panel. As was explained, my perspective, and it is such an honor to be invited by Cedric, Mariana, Jan, and Terre des Hommes, and it has been an outstanding experience to work with all the organizations who have put together the Global Initiative on Justice with Children, showing that children's law and children's advocacy and children's rights is indeed a multidisciplinary challenge and should remain a multidisciplinary challenge. And I guess it's fitting that I'm speaking about digital justice digitally, although it is only because of health reasons, so my apologies. But we can see in action all of the things that will inevitably be challenges in courtrooms and court systems that function on digital platforms like this. I'm not sure my mouth is matching my words. I'm not sure that you can see me the whole time. And of course, while we're speaking today, you never know what things will happen in my household where I'm speaking from. But I'll be brief in this introduction to share that my perspective that I'm sharing today is very much in line with what you've just heard. It's about what feels like a challenge from as a practitioner in the courtroom representing children and then advocating for children in different child justice systems around the world. My challenge, though, the stress that I'm going to emphasize today is not between child rights and public safety as much as it is between the push and pull of preserving the best interest of the child in a court system and in a justice system, while also preserving the fundamental human rights of children and the fundamental rights that are owed to anyone in a justice system. As a lawyer for children, that is an everyday struggle when you are in a courtroom that is at the same time looking out to affect the best interests of children and secure the best interests of children at the same time as making sure they have all of the guarantees that must be in any justice system and any courtroom system. And I'll talk more about that as we move later, but I want to put it in the context of a few things. My comments today will focus more on digital justice as it relates to children appearing in justice systems. But they're also based on an informal judge interview project that we've been doing with the folks at Terre des Hommes and the Global Initiative. And what we're learning from judges when we ask them about this is the challenges of digital justice happen all over the system. The pandemic caused digital communication between probation officers and children, between social workers and children, between lawyers and children, all outside the courtroom. And I think as we move forward out of the pandemic and people are able to interact live now more, there'll be less of a discussion about whether those things should be digital because there's less debate about whether those things should be digital. And there will be more discussions about how do we handle the interactions of formal justice systems, which sometimes come in the form of courtrooms or informal courtrooms or other tribunals. And I will share the spoiler of the end of my comments, which is that I'm advocating for making those decisions in a more child-centered way. We do have to evaluate impact, and we have to evaluate how systems, how well they work now. But as many of my colleagues have already pointed out and will discuss during the day, there is very limited information about how effective court systems are in juvenile justice settings. Not how many cases they handle, that's available. Not how many children are involved, not how many people appear before tribunals, but their impact, their actual effectiveness in distributing justice, something very hard to measure. So of course it's going to be hard to measure that same impact, whether children have received and children have been participants in justice, just like it's difficult to do for systems live. To share a perspective about that briefly, and then I know we'll get into questions, I will share it in the context of one United States Supreme Court decision, which now goes back almost 10 years, that I think really should open all of our eyes to how not child-centered our justice systems can be. In 2013, there's a decision from our Supreme Court called In Re JDB. And JDB was a 13-year-old boy who was questioned about a violent offense in his school in a room where there were school officials and police officers and him. And no parents, no advocates, no one was there with him, just those people questioning him and him, because under the law and according to the law enforcement there, he was not under arrest, he was merely being questioned. And the issue in the JDB case was whether a 13-year-old understood that he was not under arrest, that he was free to leave that room, and he had all of the fundamental rights of anyone being questioned by law enforcement, which would be to assert that he wanted to leave the presence or under our Constitution have access to a lawyer, etc. What is telling here is that the question for our Supreme Court in 2013 was whether you should consider the age of a person in determining whether they understood that they were free to leave. In this room, this international and digital room of child advocates, it seems absurd to suggest you shouldn't consider the age of a child when you're thinking about whether or not they understand complicated systems like whether they're free to leave questioning by police. But just less than 10 years ago, we're still deciding that under US law. And the good news is the decision was that it should be considered because, and the language of the decision talks about a reasonable child standard. So to apply that to our juvenile justice discussion today, a reasonable child standard is what I believe should be used in evaluating whether digital proceedings are in fact effective in protecting child rights, and a reasonable child standard should be used in evaluating whether best interests of children could have been and were achieved through a digital justice system, through a child who may be testifying, as I am, through a screen rather than in person, and more importantly, whether a child has truly participated in a proceeding when their perception of it is all through digital observations of people, that they too have they participated with witnesses, have they understood what's being said by other people in the courtroom, have they understood what is being, what opportunities they had and what choices they made. And when we work with children, we know that that's not a one-time question. Most children, when asked, do you understand, will say yes. But the concept and the ways to help children really participate in a proceeding, whether they are 4 or 14 or 24 as young adults, is to have them engage in the system. And whether digital processes and digital platforms for court systems allow that kind of engagement. If through a reasonable child standard, certain procedures can be conducted in a digital manner, then we can consider continuing them. But if under a reasonable child standard, that from the child's perspective, the impact of digital procedures do not give him or her full understanding of her rights and their ability to be able to participate meaningfully in all aspects of the system, then we're not meeting the expectations of a system, and we can't let our advancement into a digital platform continue without those guarantees. I'm very happy to share more about what judges told us about their perspectives on what children understood and what children's participation was, and of course, what the perspective is that we usually ask when we're evaluating court systems, how judges, social workers, law enforcement, other stakeholders, the adult stakeholders, whether their participation was meaningful and effective, which I will argue is almost as important as the child's perspective, but not ultimately the last question that we should be asking, which is about a child-centered, reasonable child standard for evaluating this kind of activity. I'll stop there and return to our moderator to begin questions.
Muchas gracias, Ángela, por la precisa pero profunda introducción que nos has hecho a la materia, con este caso tan interesante que sin duda nos habrá ilustrado sobre las particularidades del tema que tratamos. Y vamos a lanzaros una pregunta, así que os pediría que, dado que vamos algo ajustados de tiempo, nos ciñamos al tema. Y a mí me gustaría preguntar a Alexandra cuáles son los riesgos asociados al uso de la tecnología a distancia, cuáles son los principales riesgos.
Gracias por la pregunta. I would like to take something that Angela mentioned about the best interests of the child. I think it's very important when we try to answer this question and to think outside the box, to think that the best interests of the child and the best interests of society / equal, fair, justice system are the same thing. And that's why I said at the beginning, there is a tendency still to think if I am respecting or if I'm taking decisions informed by the best interests of the child, I'm leaving aside the best interests of society. And I think that this change in paradigm on the way we see child justice is fundamental. So I would like to answer your question by saying that it is my firm belief that justice and child justice has an incredible potential of responding to aspects of social exclusion. The reason I'm saying this is because I think there is a duty of the justice systems and professionals within the system to change the way they see a child. The more I listen to children in conflict with the law, the more it disturbs me. I think the law is in conflict with children. And I think the way justice systems are dealing with children is completely upside down. So the theoretical approach, what we say about international law is not what we see in reality. So there are many factors, answering your question, that may decrease this potential when the right safeguards are not in place, especially when using remote technology. I would like to mention again the digital divide, as it is an important issue for concern. We can't basically avoid stressing this. And we know that there has been a lot of research on how the digital divide affected access to education during the pandemic with regards, for example, to distance learning. But still, there has been very little attention paid on how remote technology leaves children with a greater disadvantage when facing the legal system. And I think the basic right to information can be seen here as a corollary to their specific right to be heard and to participate. In addition, basic due process guarantees are also under threat when employing technologies. How can we uphold, for example, the presumption of innocence of a child accused of an offense without looking into the eyes of this person? I struggle to understand. If we are to apply individualized plan, I need to establish a relationship of trust with that individual as justice professional. I need to understand who that person is. And that I struggle to understand that this is possible through the use of technology, if not well regulated. So screens, we know, create an artificial barrier between justice professional, decision makers, and the child, which certainly will have an impact on the outcomes of the justice process. I would like to mention several studies of remote witness testimony of children that have found that children were perceived as less accurate, believable, consistent, and confident when appearing over video. Another study I would like to mention showed that mock jurors were also less likely to vote to convict a defendant accused by a child witness when the child testified in closed-circuit television. So also the picture quality and the video setup may play an important role, as they can give the appearance that the defendant was not making eye contact, or situations where the video is, for example, in black and white. So basic rights such as the right to an interpreter may also be hampered by the low-quality technology for video links and create additional barriers for children to understand the proceedings. Finally, according to international law, children should benefit, we all know, from appropriate assistance and support when accused during criminal proceedings, and this may include the presence of parents or support persons during the proceedings. While they may be present virtually, the absence of physical proximity or of support persons and/or lawyers may also impact children's well-being, and, as Angela mentioned, the capacity to receive assistance and emotional support. So this is just a snapshot and a very quick answer to your question of the risks and challenges children may face when remote technology is employed. But I cannot emphasize enough the need for more research in this area to better understand this new phenomenon and the potential impact of this digital transition on children and justice systems. Thank you.
Muchas gracias por la respuesta. Le vamos a dar paso a Ángela también para que nos pueda explicar, y en la misma línea, cómo estos sistemas híbridos de tecnologías digitales pueden asegurar o no poner en peligro que el derecho de los niños, niñas y jóvenes es escuchado, el derecho a ser escuchado se respeta en los procedimientos judiciales. Cómo este interés superior del niño que comentábamos y cómo estas formas creativas que tenemos que pensar pueden ser llevadas a cabo. Seguro que con su experiencia Ángela nos podrá ilustrar al respecto.
Thank you. Apologies, I was having some trouble with sound, but I assume you can still hear me?
Yes.
I agree with thank you. I agree with everything that was just said in so many different ways. The need for research is huge. In fact, I'm going to share a couple of perspectives from this very informal, non-research based project that we've engaged in, interviewing judges about how they perceive three key aspects of what happens with children in a justice system: the judge's ability to work with children, the lawyer's ability to work with children, and confidentiality. Just examining the question from judges' ability to work with children, while judges generally comment that they feel like they can, that children understand what's happening because they go out of their way, they make changes. And the good thing is that difficult circumstances encourages innovation and reinvention. And so there are certainly reports from around the globe of many justices doing things differently than they would in a regular courtroom, spending more time checking on the understanding of children, asking them questions about whether they understand. But judges also report that delays have been a great big issue during the pandemic. And so taking all that extra time is very difficult for them. And so there's not reports about people discussing the understanding of children. There is asking them if they understand what just occurred, or maybe explaining it again, but more talking from the judicial actors and less from the children themselves. A lot of head nodding, a lot of saying, yes, I understand. That leads me to the second issue about lawyers' understanding. There was a national study done of juvenile defenders in the US around how the impact and the presence of digital platforms and courts that have gone to Zoom platforms have affected their ability. And it was nearly universally condemning of whether or not they had the same opportunity to build rapport with their clients, to spend time with them, understanding what gaps they have in understanding the system, and then, of course, being able to spend the time to discover the facts of cases in front of them. Perhaps one of the biggest concerns raised from a fundamental rights perspective and a due process perspective is whether or not there is space for confidential conversations between an advocate for a child, and in most cases, a lawyer for a child, and the child in a digital platform. Some judges came back and reported that they were doing creative things like offering breakout rooms to a child and their lawyer intermittently during proceedings, but that was rare. For the most part, what we're hearing is the communications between judges, between lawyers and their advocates has to happen very haphazardly and not completely if it's going to be confidential. I can share that in hearings that I have done over the last 2 years, we are on screen together and I am texting with a child with my phone on the side, not in the kind of format that would be best practices under any standards that have been developed over the 30 years since we've had the Convention on the Rights of the Child, and certainly not the standards that are envisioned in General Comment 24 to the Convention on the Rights of the Child on the ways children should be able to access the system, that they should be able to stop when they don't understand, and that they should have a place to have a confidential conversation to share information with their advocate so that their rights are best represented. There were creative suggestions, and the great news is as you look around, the world of child rights is always nimble and always trying to be creative in how you address these gaps for children. And just like Alexander said, what we're talking about is an emphasizing of child justice system challenges that were already there before we went digital. There was not enough time for lawyers to engage with their child clients. There was not a great understanding of confidentiality between the different actors in a setting and a youth involved in a system. And when detention is a potential outcome, that confidentiality is critical. I'll say just briefly that sometimes when we evaluate the effectiveness of systems, we think about it in terms of the functioning of courts and the number of cases being heard and the procedures where matters can be heard by a court system and cases can be disposed of, and not necessarily whether all of the cautions and protections were examined in order to consider whether the extreme response of detaining or removing a child from their home setting was the right outcome. The systems don't have to put those things at odds, they just have to guarantee that both of them happen. And the functioning of a court system, even as through the pandemic, court systems have gotten used to digital justice and gotten used to being more functioning online or hybrids as have become more common, none report an increase in the reasonable actions by courts to secure confidential conversations and good interactions with lawyers and children. And the system was already in need of an increase and improvement in that area before the pandemic hit us and this unintended burst into digital platforms began.
Muchas gracias, Ángela.
Thank you, Angela. So now let's hear the national experts that are here today with us. We would like to know your specific perspective. So Pilar Lizán, she's expert of the area of the Agency for Education and Reintegration of Offending Minors of the Community of Madrid. So Pilar, taking into account what we have just discussed, how it has been developed in the different courts, the situation of the digital environment. Thank you very much for the organizers. Thank you for counting on the Agency for Education and Reintegration of Offending Minors. We are an autonomous organization of the Community of Madrid, and we execute the judicial measures that children need to carry out, both deprivation of liberty and diversion. These measures are adopted by the courts for juvenile justice. Our goal is to represent the public entity. We represent all those professionals that are carrying out these measures in different types of courts of juvenile justice. But as I say, we also implement these measures once the sentences or the cautionary measures are expressed. So we've been analyzing different advantages and disadvantages. My colleagues have just spoken about this. And we've seen how the justice system has adapted to the current situation, to the pandemic situation. And let's understand how we can deal with these situations. Different technological measures have been implemented, and of course we need to carry out research in this respect. We need to analyze the impact that it's going to have on minors, and this is part of the understanding of the procedures. When it comes to the Community of Madrid, I speak on behalf of the Community of Madrid. We have been participating in different courts, and we have seen these types of measures, the video conferencing and technological measures. Of course, they had many advantages. For instance, not paralyzing the proceedings, enabling the children to speak with the courts. Transmitting information was quite swift. Of course, we can't forget the different advantages that technology has had, but now we'll have to analyze the impact that it will have in the long term. Now, when it comes to our competencies, since we represent public entities, we wanted to be present in these proceedings online, especially between March and April. That was I would say, the hardest part of the lockdown. And we had to adopt cautionary measures, especially in certain tribunals, because the situation asked for it. So in these 2 months, we were using technology, we're using video conferencing platforms to facilitate information and for us to speak with minors and to see that the measures were being taken care of. And then starting from May 2020, in Madrid we went back to kind of normality. So we had the opportunity to hold physical courts, especially juvenile courts, not all of them, of course, but in those where we could go physically, we tried to do that. We wanted to analyze the confidentiality aspect, and as I said, we wanted to be present in the different rooms. And starting from May, as I said, starting from May, the normality came back, kind of. So for 2 months, we were experiencing these online hearings. Of course, we need to carry out cautionary measures. We can't stop that, so we need to do something. Minors, children need to have access to lawyers, to have constant communication, and as you said, we lose this sort of bond with the lawyer. Maybe there is a lack of confidentiality, of this sort of security, but of course we needed communication somehow. All the different centers that we have here in Madrid had a video conferencing system to guarantee the rights of children and allow the communication between them and their lawyers. And of course, we held different hearings. Our law is quite flexible, so that is why we can constantly change and adapt judicial measures to the changing situation of minors. We needed a constant communication with the courts, and that was facilitated. There was no problem in that sense. Now, when it comes to the prosecutors and the judges, we carried out a follow-up, especially with the children that are detained. And as I said, judges and prosecutors visited often these centers. They had a direct communication with the children because we tried to maintain that confidentiality we were talking about, and also that direct contact between judges, prosecutors, and children. We wanted to maintain this open communication channel. Also, we are carrying out different judicial measures in an open space. Most of the children still live with their families or go to the school, and it's us who adapt to that, who go to their environment. So we had to implement different measures to allow this follow-up, and somehow we still need to intervene throughout the process. We had to merge the traditional educational resources that we have been developing over the years with digital tools. How did we do this? Well, through follow-ups, through tools such as WhatsApp or the video conferencing platforms, and having this, open follow-up system. And instead of doing it face-to-face in centers where children can participate, well, we kind of did the same thing, but with a digital platform. We wanted to guarantee also psychological support in these supervised release systems. And it's true that we didn't have to stop, for instance, a therapeutic process. We maintained these, as I say, through online channels. It is not the perfect situation, that's for sure, but it's important to maintain the contact between teachers, mentors, and the children. That was not so difficult, but when it comes to the supervised release, that was a bit more complicated. But it was certainly better to adapt than just to abandon the process. So I would say that we were able to adapt to that. Now we speak a lot about resilience, right? We hear this word all over the news, and it's about that. It's about adapt. It's about being able to resist adversity and maintain the execution of all these measures. I think we were able to secure the rights of children. We should not forget that in Spain, children's justice is more focused on the educational part of things and trying to improve that area in order to avoid that those events would happen again. Of course, we have done a lot, but we can always improve. And we need to make sure that all these guarantees are maintained. But as I say, I think at least we were able to adapt, especially considering the serious situation we were living, this pandemic, in 2 years already. Thank you, Pilar. So now we'll go to the third sector for the entity for infancies. So Cristina San Juan, she's an expert in awareness and child policies in Save the Children Spain. Speaking of justice in the digital world, I think, Cristina, that maybe you can tell us what is your approach from your organization, especially regarding the general comments number 25, and tell us how do you think this can affect. Hello, good morning. Thank you very much for inviting me. I will try to be brief and straight to the point. So the general comment number 25 was adopted last year, and it's focused on the use of technologies by children against violence in the digital environment. But it also speaks about the interaction between children and the justice system and how technologies play a role in that. So first of all, I think this general comment is very important. And I think we should speak in practical terms, and that's what I'm going to talk about today. The general comment establishes that technology regulation needs to look at the interests of children. And now something comes to my mind: resources. What are the resources to carry out or to implement this type of policies in the digital environment? And also when it comes to the children, we need to understand how technologies can help. In Save the Children, we have analyzed this from the victim point of view and, for example, the problems, the delays of the procedures cause. There is another topic, the access to justice and remedies. This needs to be adapted, but how? Well, first of all, we need to inform about the mechanisms of the judicial system. There is another topic, the rights to privacy. We have been speaking about it. All personal data in digital environments, well, how do we tackle this? Well, it needs to stay under the protection of authorities who are authorized to use this data. And now I would also like to mention something else. We speak about cyber delinquency and online crime and how this can affect children. These children, they can generate sexual material, and we need to understand how to tackle, again, this cybercrime. Digitalizing justice can have a negative impact because there is this lack of contact, and I think this is the point. We need to find a balance between the bonds, the personal bond that is created when carrying out hearings personally, physically, and then, of course, what we lose with technology. I have a concrete example that I would like to mention. And in some countries is used with offenders. I'm speaking about children maybe over 14. It's a special model. It's a Barnahus model. It's a way to comprehensively study the victim. All the actors or the players, they gather together, and what they do is to digitalize the witness of children. This is done in a room, in a friendly environment. It's a closed communication. There is a professional, a forensic psychologist, and they interview the children. And then the judges, they can ask questions to the psychologist, who is the person who is an expert, and they will be able to communicate with the children in a different way. So, in the Barnahus model, we are maybe not speaking about the conflict of not looking in the eye to the children, but rather to the fact that they are accompanied, they are not alone. This model wants to guarantee that there is a communication, a mediation. So that is why it's very important that technology goes hand in hand with the training of professionals. We need to be trained as well, but we also need a quality technology system. We mentioned that maybe there was some black and white videos or Zoom who cannot be amplified. And as I said, this is something that needs to be taken into account. Not everything has to be held online, but not everything has to be held physically. So I think we need to find just the right balance. Thank you very much. Thank you, Cristina, for being brief and straightforward. But also, I think you mentioned some interesting points. And finally, we will lead the floor to José Antonio Luengo. He's the deacon of the College of Psychologists in Madrid. And he will speak about the last topic, which is educational centers. What can educational centers do to provide education in terms of technology?
Thanks very much, Carles. And thank you as well to the organization for thinking that we could actually contribute to these very interesting topics from our organization. We experienced the lockdown, and the way we have reinterpreted life during the lockdown and even since then, it's very paradoxical. We have found some keys. We have come up with some ideas that make us see life differently, a lot more differently than what we were used to. Of course, this will always be a challenge. However, I'd like to add that, in a nutshell, this change in the way we live has promoted a change, a social change, that I believe was not satisfactory, to be honest. Not fully, at least. We have been able, indeed, to use technology to fulfill some needs adequately. That is true. Psychology is always looking far ahead. We're looking into childhood and adolescence. These are vulnerable groups of individuals. So they have vulnerabilities, but they also have fundamental rights. And one of these fundamental rights is, of course, the access to justice, as we've said. We've talked about criminal justice, but we all know that our children and adolescents are facing a bigger challenge. And that bigger challenge is civil justice, social justice. Children normally have to face very difficult situations, derived from breakups, divorces, for example. I've been working with children for years in the community of Madrid, and I've seen it myself, that most of the problems children were dealing with, most problems children's rights were not respected for, had to do with these relationships between adults. Adults lose track of what they're doing, and that affects children. We have this egocentric, anomalous, selfish behavior of adults. And the problem is that adult misbehavior affects the rights of children. We've seen in our educational centers quite a few things. One of said things was how to approach the needs of children, socially speaking. When it comes to education, what I'm talking about is the learning process of children, basically. And what we saw was that we were not successful. We do have sufficient tools, hardware, software, platforms. We have the means and the resources to do things right, but we have not managed to do so. Within the vulnerable, we have the most vulnerable groups, and these groups have lost many opportunities of accessing education, mandatory education, for several reasons and circumstances, all of which have to do with what we've talked about, especially, this digital gap between social groups. Luckily, this has been, worked on, and we are trying to reduce the negative impact this has. But still, we can see that technologies in these development processes are still very present. Of course, during lockdown, these technologies offered a great window of action. Of course, they allowed us to interact. But then, what I want to say is that it's not only about the content, but how we access that content. These ways of communications that we have are good, but we need to work on the link, the relationship, the contact, the safety that we share, that we transmit. Children find themselves in unfamiliar situations, and sometimes they can be very overwhelmed by these. And this could be even in a classroom. When they're discussing things in class and they see their little classmates through a screen, or they see their teacher through a screen, through a platform, sometimes it can be very difficult. And if they have that at school, what can they not have when they have to do that for therapy? We should focus on the protection. And in this regard, technological advances and platforms have a lot of work to do. As we said before, as we move on with this, if we give up the in-person meetings or in-person relations, we're kind of giving up on an essential aspect of life. How could I face, this litigation, this court procedure, digitally? Imagine a couple who decides to divorce, or imagine there's some kind of crime involved in this. How can children be affected? Can children move? Can children explain things again? Can we go back on one topic? All of these are essential aspects of the procedure that sometimes get lost along the way, because online platforms do not have room for this. And I'm not saying this will never happen in online platforms. I may be completely wrong about this. And we should maybe discuss about the metaverse, because we know where it's coming from, but we don't even know where it's going. We may find in there some responses to these challenges. And right now we can't even begin to fathom what could happen. I like to insist, we've experienced so much over the last few months in psychology, particularly during the lockdown time. We had tools at our disposal, and these tools allowed us to, cover some gaps that we had to kind of solve this dramatic situation, or at least kind of palliate and reduce the negative impact. we were trying to help in some situations. These allowed for us to see how communication, how we could even have notifications and conferences, all of these have apparently solved, this need for interaction or exchanging of opinions. That's good. However, when there are children involved, there's a lot more at stake. We're talking about the rights, the psychological development, and everything else that my colleagues mentioned. Of course, and this is a fact, that in any legal procedure we need a link, a relationship with a child. Of course, on a day-to-day basis, we find ourselves in very difficult situations and in very, very dramatic situations sometimes. I personally had the chance to experience some very negative management of in-person meetings. I would like to stress out the need to show that when we go back to in-person meetings, the rights are still preserved, especially when children are involved, because these children need to have the rights totally respected. Children need to feel safe, need to be protected, and they need to feel that they can actually speak and go back if they don't feel comfortable in some situations. Because these situations may arise. It's normal in any legal procedure. I think for now, in our areas, we are improving this. Churchill did say that we should never, take for granted a good crisis, and we should make the most of one. But in our case, we do have some improvements in the digital world that we've covered. Some more improvements will come. But this digital evolution has also manifested the challenges ahead, and this is something we should not forget. Thank you. Thank you very much for all of your inputs. Very interesting. I think we've covered most of the aspects that we wanted to cover, all the sectors, private sector, academia. For now, we will ask some questions if you are interested. This is a very flexible time now, so you're very welcome to exchange opinions. We'll, of course, follow some order, but please feel free to participate and take the floor if you want to. So I invite now everyone to, if you want to come up with any question or have any comment, please feel free to speak up now. Thank you. Do we have any question? I do have some questions, but if no one wants to listen to me any longer, please just come up with some questions yourself. I'll be very happy. Okay, I don't see any questions for now. Last chance. All right, then let's go for my question then. Alexandra, I think there is one topic that came up in this discussion. How can this technology help society in general, children in particular, but also what can the UN do to support member states to come up with, to make sure that these processes are actually good and that they help children? Thanks very much for your question.
I just would like to reiterate that remote technology is here and it's useful and it can help, but it can serve the interests of both society and children if applied in full respect of child justice principles. And if there is a legal, policy, institutional and operational framework that will put in place all safeguards as set forth in international law. I would like to say that the UN alone can do absolutely nothing. And this is the kind of forum that shows that we can only do something if we are together addressing efforts towards the same direction. I would like to mention something that I have been involved in the last years, and that is, back in 2015, I started working on revising juvenile justice in the context of counterterrorism. When I started that work, some people were telling me, but what are you saying? Are you just repeating the principles of the CRC? And now, after 7 years, I realized it was important to repeat the principles of the CRC to avoid that security takes precedence over child rights. Now, after the pandemic, or while the pandemic is still ongoing, unfortunately, I think that we are running the risk of technology preceding the interests of child justice. And we can't afford waiting to see what will happen. So I launched a suggestion here that just came to my mind while listening to the discussions. My suggestion is the following. I belong to UNODC. UNODC is an office of the United Nations Secretariat. So we have 3 functions: research, the development of international normative instruments, and technical assistance. Research is needed, but I don't think we can afford to see the results of research. I think we have to be super fast. And we have to be super fast because courts all over the world are adopting policies and procedures on the use of remote technology. So I launch here the idea, perhaps as a follow-up to this forum here, shouldn't we think of developing guidance to courts or to member states on how to make use of remote technology in full respect of child rights? So this is a very concrete proposal. And if we do that, I think it should not be the guidance provided by the United Nations, but the guidance provided by a variety of stakeholders, psychologists, civil society organizations, professionals working for the rehabilitation and reintegration of children, those that are in contact and understand the problem from different perspectives. I think that we have an incredible opportunity here to help member states that are in need. And by the way, this is technology serving the purpose of efficiency and efficacy of justice, of the performance of the justice system. We will end up serving the purposes of lawyers and attorneys that will find irregularities in these proceedings when child rights are not respected. And I'm looking at you, Angela, because I think that we need to put forward here guidance, guidelines. I am very hesitant to use the word guidelines because then we need the approval of all member states in the world, but guidance for courts to adopt procedures that are in line with child justice. Thank you.
Yo creo que ha salido una propuesta muy bonita que tanto
I think this is a very interesting proposal.
expertos, academia y todos los
I
agentes
think
implicados
experts
podamos
and
trabajar
the world of
conjuntamente en
academia
esta
could
materia
work together
para
for this
países,
particular
para que
purpose.
el sistema judicial se vea enriquecido.
I think it's very interesting and the judicial system would benefit from this initiative.
Que si queréis hacer algún apunte para terminar,
If any other member of the table would like to comment on this, Angela, do you have any comments on this issue or anyone else?
Only one point final from me that I completely agree with Alejandra's assessment. We cannot wait. Things become part of the practice of courts very, very quickly. And so we're going to have to undo bad habits that have hindered due process rights of children and have hindered best interests of children if we don't do it quickly. So it'll be exciting to work in Madrid and with so many others online who are thinking about this right now. Child-centered all the way through.
Muchas gracias, Ángela. ¿Sí?
Thank you, Angela. I would like to make a small comment. All of the actions involving not only humans but children and adolescents require an impact evaluation, an impact assessment. We need to assess what has happened, and doing so is particularly important. And the truth is, this is very rarely done in reality. We are moving so fast and we are so stressed out about moving forward and doing things fast that we tend to forget this along the way. But it's very important to focus on communication as well. And I insist this assessment is fundamental. In the case of children and adolescents who have not been able to go through education or therapy comfortably, we are working on this actually. Therapy-wise, we are trying to analyze how or what are the impacts of therapy on a digital environment. And I think that's essential. I'm told we should finish soon, but please go ahead and one little comment. I like to insist that technology is here to stay, and that is a fact. The children we work with already have social relations in the digital world, and we cannot forget about this. We should at least insist on the figure of the educational figures, because they are the ones who should, look for alternatives. They should analyze or help children analyze the environment and what's going on. We shouldn't only focus on the technological part of judicial systems and judicial procedures, but I believe it's fundamental to have this figure accompanying children throughout the process. We're talking about individuals. We're not talking about procedures. We're talking about people here. And it's very important to have them involved socially, proactively, and socially. And all of that requires academic support for children. We will finish now. I think it was very interesting what we talked about. We discussed children's rights. We discussed confidentiality. We discussed approaching all of this, centering everything on children. We discussed how children's rights, all of them, ought to be respected. We discussed vulnerable groups and how it's very important to adapt to circumstances. It was very interesting as well to consider the digital gap as a possible means of discrimination as well. We have a lot of work to do. I am now told we have a 15-minute break and then we will move on to the next debate. Thank you everyone for attending. Thanks.